Welcome to the Supreme Court of the United Kingdom. We are going to be hearing the appeal in the case of KE Entertainments and Her Majesty's Revenue and Customs. The appeal is concerned with questions of the law governing value-added tax. Details of the case can be found on the court's website if you follow the link to current cases. I'm Lord Reed, the President of the Court. I'll introduce now the other members of the Court who will be sitting with me on the appeal. First, Lord Hodge. Secondly, Lord Lloyd-Jones.
Morning.
Thirdly, Lord Sales.
Morning.
And lastly, Lord Leggett.
Morning.
This morning, we will be observing the minute silence at 11 o'clock for key workers who have lost their lives due to coronavirus. The court will also have a short adjournment between about 11:30 and 11:45 when we reach a convenient moment. The appeal is being presented by Mr. Roderick Cordara, Queen's Counsel. The respondents, the revenue, are represented by Mr. David Thompson, Queen's Counsel. I will hand over now to Mr. Cordara to present his submissions.
My lords, I appear in this matter for the appellant taxpayers. The commissioners are represented by Mr. David Thompson, QC, who is leading Miss Elizabeth Roxburgh. This is an appeal from a decision of the Inner House of the Court of Session dated the 13th of December 2018, allowing an appeal by the commissioners from a decision of the Upper Tax Tribunal, Lord Ericht, which had confirmed a decision of the First Tier Tribunal. Lord Ericht's decision is at page 46 of the bundle, although I don't invite the lordships to look at this moment. Lords, the single issue of law raised in the present appeal is whether the change from a game-based to a session-based formula for ascertaining the taxable turnover of operators of bingo halls gave rise to a decrease in consideration for VAT purposes. And the answer will emerge from the view your lordships take of primarily, in our case, the European legislation in the principal VAT directive, articles 73 and 90, and or the UK legislation, section 19, particularly 19.4 of the VAT Act, and more specifically, regulation 38 of the VAT regulations, from which I picked the phrase decrease in consideration. My lords, since the service by the appellant of its case on the 17th of March this year, there have been two developments which I note at this stage and will return to as far as necessary. But they do potentially narrow and simplify the issues before the court. The first came yesterday in the shape of an email from those representing the commissioners, indicating that the commissioners will not seek to support the view expressed by the Inner House through Lord Drummond-Young, I think specifically, that the word consideration in the UK VAT regulations, Regulation 38, had a meaning other than its normal VAT European law meaning. Commissioners do not seek to support that, and I will return to that and its implications shortly. Secondly, and perhaps slightly less obviously, but of equal importance, I draw to your Lordship's attention now wording in the case served by the Commissioners at paragraphs 8.4 and 8.12, and again, I will open these later if I may. They are in the region of page 185, I think, of the bundle. There, the Commissioners appear to be inching towards a position in which they accept, at least in principle, that a game-based approach to calculating the taxable turnover is a valid and lawful approach. As your Lordships will well know, there are two approaches in this story, the game-based and the session-based. It is our contention that both are lawful and valid approaches, although they give different figures. And if indeed the Commissioners do reach that point, and we shall have to see when my learned friend addresses you, that will greatly, potentially greatly simplify the issues, because that will potentially remove the Section 80 issue, which is intimately connected to the question of whether there was a mistake made by the taxpayer in following the original requirement that there be a game-based approach. And that will enable the court to decide the main issue, which is the central issue of what the European legislation seeks to achieve. So I've made those 2 points. One other threshold point is an obvious one, direct effect. Articles 73 and 90 are both directly effective, so they afford rights to taxpayers in the United Kingdom, irrespective of whether they have been implemented in UK legislation and irrespective of how they've been. So although the Commissioners are entitled to say and will say the taxpayer should bring itself within Regulation 38, we will submit that we can. At the end of the day, the critical question for your Lordships is, do we bring ourselves within the European system? And by the European system, I mean specifically Articles 73 and 90 of the Principal VAT Directive. My Lords, just as a footnote, for ease of presentation, I will be referring, as I think it has been the case below, to those 2 articles, neither of which was in force when the events occurred, but both of which simply are a reflection and continuation without material change of the 6th directive, Articles 11A, 1A, and 11C. And that will be the convention that I adopt. So, my Lords, with those opening comments made, I would propose next to invite your Lordships to look at some of the primary documents, and what I have in mind are the public notices and the invitation in 2007 to make a claim. May I say that my purpose in doing this is limited. The messages, as it were, that came out of the stream of public notices prior to the watershed in 2007 are neatly distilled in the statement of facts and issues in paragraphs 10 to 12, but in particular around paragraph 10. And it is helpful because mere perusal of these notices without a background in the industry is not a straightforward matter. That said, there is no issue between the parties that I use the word message as a neutral word, message which came from the run of notices up to 2007 was, please use the game-based method for calculating the taxable turnover. Those notices, just for your lordship's note, are in the bundle at 405 to 428. I will open one of them in just a moment. The message post 2007 is, of course, or was, of course, please use the session-based approach. And that run of notices appears at 441 to 452. Then, just to show your lordships the last of the pre-2007 notices, I invite your lordships to turn to the notice which starts at page 423. It's got the date, it's notice 701/27, and it has a date of March 2002. A very high-level glance. So this is the last, as it were, of the old school notices. If your lordships have that, as you can see at the bottom of page 423, there's the words introduction. What is this notice about? Quote, this notice explains how VAT applies to bingo. It explains the VAT liability of your income and how to calculate the amount due on your VAT returns. End of quote. We see who it is aimed at 1.2. Then if one turns the pages past page 424, which is a page which concerns different kinds of VAT, different kinds of bingo, I should say, and turn to page 425, there at 2.2, the first two bullet points place us in the very arena that the case concerns, the distinction between stake money and admission charges. So this is the voice of the commissioners, mindful of the Glauber Spiel line of cases, of course, explaining this critical distinction. And then at the bottom of the page, the commissioners take up the challenge of explaining to the taxpaying community how to apportion. 3.1, how do I apportion composite charges? And I won't read the words there, but we're familiar with that challenge because it lies at the center of the case. And then finally, with this notice, would your lordships turn to page 426, where the commissioners say you must first, stop the page, you must first calculate and deduct any amount due for admission. The value of admission is standard rated for VAT, see paragraph 2.2. You will then need to work out the value of your participation and session charges using the formulae in paragraphs 3.2 and 3.3. The liability of participation and session charges is explained in paragraph 2.1. And then at 3.2, which is the only table or formula that concerns your lordships, one sees the various steps. Those words do not in fact change after the watershed. It is in the background that the approach changes from a game-by-game approach to a session approach. I draw your lordship's attention to the perfectly accurate use of the word formula. And of course, as your lordships will know, it is part of our case that this entire exercise starts life as a formula and we answer the so-called real-world change point by saying that it finishes life as a formula, albeit a different formula. There is then at 441 the post-watershed document, which is
just before we leave this document, where does it actually tell you to do it on a game-by-game basis?
It doesn't. One has to track back through the earlier documents, and that is why I was careful to refer to the statement of facts and issues, which does the work for it. It's quite a lot of work to distill the messages, which we can do, but if I could, for the moment at any rate, commend to your lordship. I'm just looking for the page. I'm looking for page 99 of the bundle. This is common ground, and if I've taken an undue shortcut, I apologize. But if your lordship would be kind enough to look at page 99, paragraph 10, there is the agreed distillation. As I say, I can come back to this later. And it says there, quote, prior to 2007, HMRC's leaflets and notices with reference 701/27 ... stated that the methodology to be used to identify the element of a taxpayer's turnover that was deemed to be taxable turnover, bracket, as opposed to the stake, close bracket, was that based on an individual game-by-game approach. So that participation fees were taxable in full, even though they might sometimes be used to fund additional prize money, etc. And indeed, your lordship will, in the document to which I'm about to go, your lordship will see some further confirmation of that. Yes. So, my lords, if I can invite your lordships to turn to the first post-watershed document, which is at 441. That is September 2007. It's in the same series, 701/27. Once again, at 1.1 on that page, we see, quote, this notice explains how VAT applies to bingo. It explains the VAT liability of your income and how to calculate the amount due on VAT returns. I haven't said, but your lordships will, I think, have picked up that VAT hasn't in fact been charged on bingo for 14 years. This case has a purely retrospective impact. Coming to the next relevant page, which is 445. The pages in between 441 and 445 are dealing with other forms of bingo, which are not the form that concerns the case. At 445, one sees again the stake money admission charge distinction at 2.2. Then turning the page, one sees the game versus session basis grappled with expressly. And before I get to that, 3.1, as your lordships will see, once again, words you must first calculate and deduct any amount due for admission and so forth. And a reference to the formulae. And then in 3.2, there is this new heading, should I calculate the VAT on a game-by-game or on a session basis? And quote briefly, when players pay to participate in all or part of a bingo session, the supply you make to them is the right to participate in the number of games during that session for which you have received payment. As the players can't participate in further sessions unless they make further payment, supply to the players is completed when the session ends. In these circumstances, you should calculate the amount of that due on participation and session fees on a session-by-session basis. And then there's end of quote, there's a reference to separate games, which are still done on a game-by-game basis. And then something which I think appeared before, but I failed to read it. You should not, in bold, perform a single calculation for the whole of each VAT return period, aggregating stake money and receipts taken for all bingo played during that. So putting on one side the question of whether it's a single or multiple supply, which I don't believe is a matter that your lordships will be troubled with, although we did deal with it in our case, that I think can entirely be set aside. What we see, if I can couch this in terms of the EU law cases, is the United Kingdom authorities focusing on the phrase which we see in the Glover-Spiel cases, a given period. In the Glover-Spiel line of cases, there is reference to working out in these money-for-money or gaming transactions consideration, quote, over a given period. The same is true of the Forex transactions in FNBC. And what the United Kingdom is doing here is giving a revised view of the given period. And of course, the given period is only shorthand for the number of transactions which will be put into the globalized approach for the purposes of applying the Glover-Spiel. And therefore, we have a new formula in effect. And then at the bottom of the page, there are the various steps which I won't read aloud. So that was the new position. The final document in this part of the bundle is the invitation at page 451 to make a claim. There at 451, and date is the same as the document that your lordship has just been looking at. We see VAT, cash bingo, accounting for that on participation and session fees. This briefing is about participation and session fees paid by cash bingo players. It clarifies HMRC's policy on how to calculate those fees for VAT purposes. Background: participation and session fees charged for taking part in bingo played for cash prizes on premises licensed or registered under Part 2 of the Gaming Act, are consideration for standard rated supplies. Stake money, the amount risked by the player, all of which must be returned as winnings, is not payment for a supply and so is outside the scope of that. Where participation and session fees and stake money are received together in one composite amount charged to players, bingo promoters must work out how much of the payment is stake and how much is the participation and session fee in order to determine how much that is due. Section 3.2 of the notice 701/27 bingo explains how to do this. We received inquiries from some bingo promoters performing the VAT calculation on a game-by-game basis, asking whether they are acting correctly, and these have prompted the issue of this clarification. And it goes on, I won't read it aloud, but it goes on at the bottom of the page to indicate that the charges should properly be calculated on a session-by-session basis. We're familiar perhaps with that message, but maintains at the bottom of the page, the last new sentence on page 451, where money from other sources is added to the stake money received in session in order to meet guaranteed prizes. That additional money cannot be used to reduce the value for VAT of the participation in session charges paid for taking part in that session. So I turn to the next page with a slightly different focus. I invite your lordships to note the further instructions at the top of 452 as to detail in terms of aggregation, globalization, as I described. And then there is a new heading, making claims or adjustments. I'm focusing on this obviously because it's an important part of the story, also because there is some disagreement between the commissioners and the appellants as to the precise message. The commissioners say this is a Section 80 VAT Act message. We say it is definitely that, we accept that. But the reference to adjustments means that it is also a Regulation 38 message. And I'll explain that right now. So claims we say is code for Section 80, adjustments we say is code for Regulation 38. The text says bingo promoters that have calculated the VAT due on participation and session charges on a game-by-game basis, and who now find that they have done so incorrectly, may make a claim to HMRC for a repayment of any resulting over-declaration, subject to the conditions set out in Notice 745, and the title is then given, how to correct VAT errors or make adjustments or claims. There should be inverted commas around that phrase. And then it goes on. In particular, businesses should note that, and then there are two bullets, which I won't read, about certain quantum of errors which require different procedures, which doesn't concern us. There is then a reference to unjust enrichment, which is clearly a Section 80 reference. There is no unjust enrichment provision in Regulation 38, and an offer of advice. The focus, therefore, is on what Notice 700/45, how to correct errors, and we invite your lordships to imagine a comma after the word errors, it's not there, or make adjustments or claims, what that says. And that can be found at page 1745, 1745.
We don't have a page 1745. At least not in the main bundle.
I'm so sorry. I've got it as tab 81 of the authorities bundle. I didn't tell your lordships that.
In a supplemental bundle.
That's grateful.
Which starts numbering at 1, unfortunately, on the computer.
I didn't know that. I've got my eye on the time. It is Notice 7. I don't have that bundle in that form. I apologise. It's Notice 700/45. Can your lordships locate it? I can always come back to this.
I'm wondering if I have the right bundle open. The main bundle goes up to authority number 80, and then there's a bundle which came in the other day, which has 83 and 84, and I think I must have somewhere else a bundle which has 81 in it. I'll find that number.
But I'm conscious that it's 10:59.
The court will halt its proceedings now for 1 minute to observe a minute's silence in memory of the key workers who have lost their lives to coronavirus. Well, we shall resume now.
Do your lordship?
Point does not seem to have the supplementary authorities 81 and 82.
We are, in that case, I will press the pause button as it were on this point. I've trailed it.
Yes.
And those instructing me are telling me that they can immediately let the registry have 81 and 82. So it's a very discrete point. I've indicated.
Is this notice 745? No, it's not. That's a 2002 notice.
It's the very notice.
Well, that was sent to us by email on Friday of last week. So if other members of the court are able to find an email for Friday the 24th of April, that's where it is.
I'm in your lordship's hands. Whether to go on now or park the point.
I think are you able to come back to this point after we've had our 5-minute adjournment later on?
It would be very convenient to do that.
In that case, just carry on for the moment, and those members of the court who haven't yet found the email can find it when we adjourn.
I'm sorry about the hiccup, but I'm extremely grateful. Just before we leave, essentially I've left the primary business briefs behind. If it's of any assistance, may I draw to your lordship's attention that Lord Drummond Young, and this is a background observation of his lordship's, with which there is no quarrel, at paragraph 36 of his opinion, that's page 218 of the bundle, Lord Drummond Young said, speaking of the game-based approach, and I quote, "It was generally understood that was required by HMRC." And that, with respect to his lordship, we would submit is a fair, objective comment on the message, as it were, and how the message would be seen by the reasonable taxpayer. In terms of the new post-watershed document, which I've just shown your lordships, his lordship also said at para 37 of his opinion at page 220 of the bundle, quote again, "The paragraph headed calculating the VAT due amounts to a clear indication that the session basis should be used in calculating VAT on bingo games." That was page 220, para 37. So once again, I simply commend those to your lordships as, with great respect, accurate descriptions. My lords, I will come away then from those documents and just take a moment to remind your lordships of the statutory landscape here. I'll do it obviously extremely briefly. The Principal VAT Directive, Article 73, is at page 488 of the authorities bundle, and that, as your lordships of course know, uses the word or uses the phrase. So it's 488. It's at the bottom right-hand corner of the page, and it reads, "In respect of the supply of goods or services other than as referred to in Article 74 to 77, the taxable amount shall include everything which constitutes consideration obtained or to be obtained by the supplier in return from the in return for the supply from the customer or a third party, including subsidies directly linked to the price of the supply." And there is then at 490, top left-hand corner, Article 90, "In the case of cancellation, refusal, or total or partial non-payment, or where the price is reduced after the supply takes place, the taxable amount shall be reduced accordingly under conditions which shall be determined by the member states." Nothing turns on that last phrase. These are directly effective provisions, and that means that member states don't have a discretion not to apply them. The phrase, "or where the price is reduced after the supply takes place," is of course center stage in the real world change argument, which found favor in the inner house. And the phrase in Regulation 38 is a decrease in consideration. Anything in Regulation 38 ought, in our submission, to be construed in light of the directive. And in terms of the Commissioner's email on Monday, that would have been...
Which was the provision in the directive you were last referring to?
My Lord, it was Article 90, sub 1, page 490, top left. And I had focused on within that, the phrase, "or where the price is reduced after the supply takes place." And that is the central issue for your lordship's decision.
How do you say the price is reduced after the supply takes place? Yes. The supply is the supply of the games constituting the session.
Indeed.
And the in what sense is the price reduced after the supply has taken place?
My Lord, that is the central issue, if I may say so. In
that case, I'll be patient.
No, with great respect, that is the issue, and the tax tribunals took the view that the change in the approved Glauber-Spiel formula, if I can use that phrase, which I've been showing your lordships, given that that formula is the only gateway to working out what the supply is, there's no contractual guide, of course, because there's no apportionment between the players and my clients. So that is the core of the case. We say that if that officially approved formula changes, being the only way knowing what the price is, or what the consideration is, then the supply has been reduced. The price, which is a synonym for consideration, is reduced after the supply takes place. and the
supply that you get is the right to participate in the session. I must say that I have difficulty in seeing why the session basis isn't the correct basis. So I'm not at the moment prepared to accept your premise that each basis is as good as the other.
My lord, that is a point then I should come back to, but may I respond briefly straight away? What in fact is being done in the Glaber-Spiel line of cases is looking at the economic reality of the business from a VAT point of view. Now, that is an exercise which is designed, obviously, to work out what the taxpayer can take for itself within the meaning of those cases, to which I will turn in a moment. Where the line is drawn as to game or session, or mainly session but a bit of game, or 1 week's takings, winnings, payouts, or 1 month's, is logically completely independent of the number of supplies that are made, and this is dealt with in our case, and I will come back to this if I may, but if I can just trail my response at this stage. This is dealt with in our case at 114 on page 148, to which I will, if I may, return. So whether the supply is for session or multiple games within a session, the overall business, and one must recall that VAT is accounted for quarterly or monthly. In my case, my client's case, I suspect it's quarterly. It could be monthly. The focus for Articles 73 and 90 will, in a gaming context, be at the level of the business, and session or game as concepts function in order to give effect to the phrase over a given period, not for a given supply. And it's critical in what I've just said that we see over a given period for what it is, and I've already made this point. It's code, because we're looking at a globalized assessment of consideration, not a supply-by-supply assessment. This is all in that paragraph 114. And as such, it doesn't matter whether it's one supply or a group. It's simply where the state draws that temporal boundary over a given period. So it may be that I can't improve on that answer later, but if I could just reserve the position to come back to it, my lord.
I mean, an alternative view might be that this is very simple. We're told in the SFI, in the Statement of Facts and Issues, that the customer pays in order to participate in a number of games forming a session. And so the customer pays for a session, and what he is paying the supplier of the session is the amount that is handed over, less the stake element, which is the amount which is being returned in the form of prizes. And if you look at that for the session, then that's the formula which the 2007 notice stipulates.
My lord, there are 2 points perhaps to be made in addition to the answer I've just given to my Lord Legate. One is from as the SFI also says, I'm reaching for it, the customer's paying to take part in the games. The games of bingo.
Yes.
I'm reaching for it. I may find it quickly, I may not.
Page 97.
I'm grateful. And in paragraph 1 on that page, third line from the bottom, the customer is there to play individual games of bingo.
Well, yes.
And
But if you look further up, a customer who wishes to participate pays a unitary fixed fee to participate in a number of games forming a session. The unitary payment, line 5, entitles the customer to take part in a number of games, each of which is a freestanding game with its own winnings, and he's there to play individual games. That's true. But what he's paid is a unitary payment for the session, and he receives back part of that payment in the form of the stake element, out of which the prizes are paid for.
And we're talking now as to, my lord, what we're talking about here is how the apportionment of the session, the overall consideration, is to be made, and the United Kingdom's approach up to 2007 was that the given period, phrase we'll see in the cases in a moment, was to be each game of bingo, and therefore any excess prize money from game 1 could not be used to reduce the taxable amount by being applied as part of the winnings. I said excess prize money, I should have said excess income over the prize money in game 1 cannot be used to reduce the taxable turnover by reference, by being set off.
And to the extent that one game subsidized another game within a session, that part of the stake element was omitted from the account.
It was deliberately treated as a given period for the calculation of the taxable turnover, or to feed into the calculation of the taxable turnover for the entire session. So that was the formula that was used up to 2007. We will see what my learned friend says, but it would only be incorrect if it was in principle a game by game based formula was unlawful. And as I read the case for the commissioners, and I have in mind 8.4 and 8.12, which I ought to, in light of the questions, I should come to that now. The issue before your lordships doesn't turn on any contention that in principle a game-by-game approach is inconsistent with principle. If your lordships would be kind enough to look at bundle page 185, as I say, my learned friend will explain his position in due course. There is the context of 8.3, which is section 80. And I should say, the issue is not whether one is, quote, better than the other, but whether game-based is within that part of the spectrum of possible answers, which is reasonable and compliant with the principles laid out in the case law. Of course, my clients, they took the money and from their point of view, session-based is better. However, it is, of course, central to our case that game-based is equally lawful, somewhat less generous. And no doubt on the other side of the session-based, there are those who would say that it should be done on a weekly or a monthly basis with all the winnings and receipts being set off. So but if I can focus on 8.4 for a moment.
The revenue's justification in the notice for not doing it on a weekly basis, for example, is that what is at least the supply is the supply of a session. And so in order to work out what is being charged for the supply, you look at the difference between the amount that a customer or customers pay for a session and the amount of those fees that are returned to them in the form of the prizes given in that session.
My lord, yes. And that was the, as it were, the post-watershed, the post-2007 approach. And it is a better approach. And the more globalized the accounting, whether it's session, evening, week, month, quarterly, the better from the taxpayer's point of view. The question, however, in my submission is, was the game-by-game basis, which builds up the consideration for the session, treating each game as what it is. It is a game, it is a contest, etc. And it has its own independent economics, as it were, whether that was unlawful or outside the spectrum of that which would be acceptable in terms of the VAT system. And while it's less favorable, and one sees the greater attractions of the higher levels of generality, we don't understand it to be an issue that a game-by-game approach is not an approach that could properly be taken lawfully, and would represent the proper operation of the Glauer-Spiel principles.
On the fact, Mr. Kodara, is it not the case that the session is quite an important aspect of the way in which the bingo halls operate, because they will incorporate into a session one or more games that have a guaranteed prize, a jackpot, if you like, which is more than paying customers are actually putting in payment for that game. And that's part of that's one of the attractions, to get customers to come along and pay for a session and play the games.
My lord, I can't remember if there's a specific finding on that, but that appears to be, if I may say so, an entirely likely situation.
And if that's so, if you get the customers to come by offering a jackpot game in the session, which has to be cross-subsidized by the games, then the pre-2007 calculations were failing to reflect that reality by treating each game as if it were an individual supply.
Well, two comments, if I may. First of all, I'm not sure we have the factual findings about the cross-subsidization. I obviously see the force, with great respect, of what your lordship says. But I don't think we've got the economics, whether each game, as it were, must wash its own face financially, or whether the finances are done on a session basis or on a broader basis. There may be finances for Saturdays which differ from finances Tuesdays.
Well, there's an explanation of the FTT adopted the explanation given by Gordon Reed, QC, sitting as the FTT in Carlton case, where this is explained.
My lord, yes. But coming back to your lordship's question, the economics, as it were, in the background, which are important in one sense, don't undermine, in my submission, the approach which one has here, whereby the game, which is the unit, certainly from the customer's point of view, of supply, it is the game that the customer wins or loses or sits out by going to have a drink in the bar. There are weekly jackpots and so on. So and this isn't one of those VAT cases, perhaps, when one is looking at the single multiple supply question. Is it one supplier or a group? It's a far more behind the scenes question in many ways, in terms of where does the state permit the line to be drawn for the purposes of the, as it were, the inherent set-off which comes with these cases. And by these cases I mean cases where what is being supplied is essentially money in return for money, albeit only to the winner. And then you've got the foreign exchange case off to the side, but which is also a money for money.
Now, Lord Hodge was wanting to ask a question.
Yes, Mr. Cordara, you're being pressed, obviously, at the moment on whether or not there was an error rather than two alternative but equally legal ways of carrying out the exercise. Your position is the latter, that there were two equally legal ways of carrying out the exercise, that pre-207, that was a legitimate way of doing it. Post-207, there was another way. What's puzzling me at the moment on your approach is, if HMRC were entitled to have gone on with the game-by-game basis without making the change in 2007, what is the legal peg on which you hang an entitlement to look back at the earlier transactions, which were, on your case, perfectly legally taxed?
My lord, the legal peg is the offer to reopen, which your lordships have seen in the 2007 document. We, my clients, went along for many years with the game basis. And that, we say, was a perfectly valid basis. The line would be drawn at game level, session level, the evening, the week, and so forth. And in later legislation, bingo duty legislation, which is a completely different tax, it's drawn, I think, at a 5-week level. There are a large number of choices.
You say you're really just relying on that notice, which we didn't have, but we've now been provided with. You say the revenue is saying you can adjust as you please, right the way back.
The 2002, I'm so sorry, the 2007 document, which I showed your lordships a moment ago, which was with the invitation to go back, that is framed very clearly in terms either of Section 80, or we say in terms of Regulation 38, which I've yet to come. And it is framed on the assumption that taxpayers can only go back 3 or 4 years, depending on the time bars were moving slightly. So my lord,
But what power does the revenue have to waive taxation which is properly charged? If on your case, the revenue perfectly lawfully operated a game by game basis, on what basis do they have? What basis do they have for saying, well, although we taxed you perfectly lawfully, we are happy to allow you to reclaim that which you have lawfully paid? I think it's trite law that the revenue cannot waive entitlements to taxation.
My lord, in the area with which we're concerned, it is, I with great respect, fully understand my lord's point. If this were an area where there were only one right answer, then that would be, if I may say so, an unanswerable point. However, any area of apportionment, be it apportionment of input tax recovery or indeed output tax liability, and we are in the latter such case, there is a band of that which is lawful. Obviously, on either side of that band, there is a zone which is unlawful. But for example, if this were a case of input tax recovery based on some form of apportionment formula, as to which suggestions were made that there was a better way of doing it, it would be entirely open to the commissioners to take on the input tax recovery side a similar approach. Now, we are, of course, on the output tax liability side because we're in an unusual area where the output tax liability is crystallized not by, quotes, the price paid by the customer, but by a more internal assessment of how the business itself runs and where a line is to be drawn, as it were, behind the closed doors of the business as to the given period over which the stake and the prize money is to be divided. So that is a matter on which there can be a number of right answers.
So you're saying you are construing the revenue as offering you the option of adjusting your figures when they made the 2007 change.
My lord, yes, emphatically so.
Thank you.
That was a lawful offer made and accepted.
Mr. Cordara, I understand Mr. Thompson to suggest that and perhaps to accept that the peg on which the claim could be based was the fact that the earlier approach, to use a neutral expression, had been induced by the revenue.
Indeed. That is inherent in those earlier public notices. I only went to the last in time. My lord, yes. The stream of earlier notices make it very plain that taxpayers are obliged to perform a calculation in a particular way, and that, in essence, throughout the period with which this claim is concerned. And I don't believe that the Commissioner's position is that taxpayers were misled by them. We have a debate as to the status of what was said in the earlier notices. It's distilled, what was said is distilled in paragraph 10 of the Statement of Facts and Issues. But it was quite plain that that was the approach that was requested. I was about to draw your lordship's attention, if I may, to the case for the Crown, which is very much apropos the current discussion. At page 185, there is in the context of section 80, and section 80, of course, is predicated on, I'm looking at 8.3 on page 185. Section 80 is predicated on the payment of a sum of money which was not due. And it is not our case that the game-based approach, as opposed to the session-based approach, was unlawful. It was within the penumbra of lawful outcomes in a very soft-edged area of apportionment, which is what one is dealing with here. And then at 8.4, the Crown, as your lordships can see, if I could briefly read the second sentence of 8.4 of the Crown's case, quote, in particular, where a taxpayer has used one of a number of lawful methods of apportionment, it cannot be said that a sum of output tax arrived at is, quotes, not due, simply because it would not have been payable if a different method of apportionment had been adopted. Question mark. It's respectfully submitted that, subject to what is said below at para 8.12, on a normal view of the words, the statutory test would not be met in those circumstances. A calculation based on any lawful method of apportionment will result in a figure of output tax, which is due. That doesn't change simply because the taxpayer changes its mind as to which method to use. That matter does not appear to be in dispute. So I will read on, but I pause there. That is common ground. Reading on, there's a point about mistaken belief, as to which I don't believe there is any particular finding, and it's a point which, new point, I don't complain about it, but I await my learned friend's development. But up to, but excluding that last sentence, we would respectfully agree we were using a directed method, if informally or formally directed, it makes no difference. But it was a method of calculation which is, as it were, within the penumbra of reasonable approaches. And one could do it on a game basis, one could do it on a session, an evening, a week's takings, and so forth. So that is part of the answer. There is a reference to 8.12, my lord.
It's subject to 8.12.
Yes, to which I now come. 8.12 says, if I may read it briefly, to the extent, this is page 188, to the extent that the original guidance from the respondent stated the taxpayers were required, that's in bold, to undertake apportionments on a game-by-game basis, that guidance was incorrect. In cases where the taxpayer was making supplies of the right to participate in both games and sessions, apportionment on a game-by-game basis would not have been the sole type of apportionment to comply with the requirements of 19.4 of the VAT Act. It goes on, the business brief confirmed that the Commission's guidance, that is their opinion, had changed, and that it was now accepted that there were circumstances where it would be appropriate for apportionments to be undertaken on a session-by-session basis. If the guidance caused the taxpayer to believe there was only one lawful means of carrying out an apportionment, that was incorrect. That would amount to an error of law. And I break off, and it finishes by saying that taxpayers would be entitled to rely upon mistake. In the last sentence, what taxpayers were and are not entitled to do is to revisit the apportionment in support of a claim under Regulation 38 of the 1995 regulations. So the message in slightly mixed message, if I may say so, in that paragraph, in the sense that it's in the second sentence, it refers to the game-by-game basis not being the sole type of apportionment to comply with the requirements of 19.4. And read with 8.4, which says, speaks of a number of lawful methods of apportionment, says of the suggestion that because one method will give a different answer from another, does that mean that the tax was not due? And very properly, the commissioners say that that isn't the case, and Section 80 would not be activated simply because a taxpayer chose to follow the guidance, whether it was mandatory or not, but the earlier guidance that one should do this on a game-by-game basis. So we invite your lordships, my learned friend obviously will explain the position when he speaks, but we invite your lordships to read 8.4 and 8.12 as a unity, which says game by game is not the sole basis, sole type of apportionment to comply with the requirements. So the Commissioner's position is that it is among the possible lawful outcomes. It is not the sole outcome. And they've indicated that one may also apply a session-based approach.
I find rather puzzling the idea that the amount of tax lawfully due simultaneously be X and also be Y. We're not dealing with Schrodinger's cat. If the taxpayer chooses to say, using my method of apportionment, the figure of output tax which is due is X, and the revenue say, well, using our method of apportionment, the amount due is Y, can they both simultaneously be correct? If so, what does a court do faced with a demand for payment?
My lord, it is it's a discussion which one would very rarely have in a tax contest, because in every other area of VAT, you have your supply, you have your consideration, there's objective factual material, and you work out the answer. As I hope to demonstrate in a moment, we're in a somewhat unusual situation here, because by reason of the case law of the European Court, we're in a highly judgmental, not discretionary, but a highly judgmental area, if I can use that possibly slightly inadequate adjective, because so much turns in this area on what is being compared with what. By that I mean, there's a phrase in the cases, which will come in a moment, over a given period. And that's a phrase in the European cases to try and explain and make sense of this internal set-off, which one doesn't normally do in VAT, and VAT is quite unimpressed by whether a supplier has made it a profit or not. You still have to pay your VAT on the price to your customers. This is an area, however, of exception where that which is winnings and that which is retained as the fee for organizing the game, as it were, is in a relationship of netting off. And as your lordships really appreciate, one could strike that netting off bargain game level, session level, and in bingo duty, I think it's struck at a different tax, purely background comment, I think it's struck at a 5-week level. So that is how one can, I'm mindful of the reference to Schrodinger's cat, but one can have more than one right answer. And what happened in this case was there was a right answer for a number of years. The state then, no doubt with good intentions, intervened to say, well, actually, we accept that there would have been a different right answer. And there certainly going forward, there is a different right answer. We, the state, will give you 4 years backwards, which my clients naturally took and gratefully received, because we, the state, take the view that you could have come forward and proposed to us a different right answer, which we weren't accepting, and that was done.
Mr. Cordara, you say that we're operating here in a very judgmental area, by which I understand you to mean that some form of evaluative judgment has to be made as to the given period over which there is to be an assessment of the value of the supply. Whose judgment counts in making that assessment? Is it the revenues? Is it the taxpayers? And if there, as my lord said before, if there's a difference between the two, how does one resolve that difference?
My lord, were they to have been a difference, were my clients to have challenged challenged judicially the position, then ultimately the court would have to decide the matter. Faced with, if the court were faced with two reasonable alternatives, one game-based and one session-based, the court would no doubt apply principles from the tax to ask which of these two gives a more perfect answer in terms of the overall functioning of the system. So two reasonable options, and clearly the session-based, from the taxpayer's point of view, that is not an unfair place from which to take one's vantage point.
If you're saying that the court gets to decide ultimately, that rather suggests that actually there is a notional right answer, and you yourself say that the court supplies it by drawing on the general principles of underlying the tax to decide which of, at first blush, seem reasonable options is in fact the right option.
My lord, there's a best answer, but it doesn't follow that everything's become simplified into a right answer and a number of wrong answers, because it is a comparative exercise. And the real question is, was the game-based approach an objectively wrong answer? The passages I've read to you, we'll obviously hear my learned friend in due course, but the passages I've read to your lordships from the case for the Crown is not saying that it was the wrong answer. The Crown accepts that there is a better answer, or certainly better from the taxpayer's viewpoint. So, my lord, it's not a comparison in my submission between a right answer and a wrong answer. The real test is the answer within the spectrum, penumbra, of possible right answers. The game-based approach was, and there is no, as I understand it, there's no debate that the game-based approach was unlawful, or suggestion. Passages at 8.4 and 8.12, which I have just read, indicate. But a more generous approach can obviously be found in the approach which deals with or strikes the balance, as it were, at the level of the session. A yet more generous approach would be the evening, the week, the quarter, etc. So one is moving up and down a spectrum of where to strike the balance, but there will be wrong answers, no doubt, at the extremes, but there are no wrong answers in play here. We certainly don't say that a game-based is a wrong answer. My clients obviously favour the session-based, but your lordships have a situation in which there are two right answers. We have accepted an invitation to move from one to the other, not, we say, because we've moved from a Section 80 overpayment situation, but because consensually the Crown has said we will look retrospectively at this. We'd like to use a new and more perfect yardstick going forward. Retrospectively, we will allow you to apply that yardstick.
I wonder, Mr. Kodara, if we've reached a. I see Lord Leggett has a question.
Isn't the logic of your position, Mr. Cordara, that there is more than one right answer? That the taxpayer has a choice, because the taxpayer will be acting lawfully, whichever of the two means it adopts. Once you accept in answer to Lord Sales that the court decides, then it seems to me you are accepting that there is a right answer in the relevant sense.
My Lord, the court will have to decide. Your Lordship has interposed, obviously, in that example, a judicial process, the court. That, of course, comes now in our story, right at the end of the day. But looking at the dialogue between the taxpayer and the Crown at the time, the Crown came forward and said very properly, there is another right answer, you may care to avail yourself of it. And my clients did, with the Crown's cooperation, and they availed themselves of 4 years of the retrospective calculation based on the session basis. That was done on the assumption that we were in the territory of Section 80. We'll see, but as I understand the position, it is, and that's one of the reasons that I read to your Lordship's 8.4 of the Crown's case. It doesn't appear now, if I may say so quite rightly, to be the Crown's position that there was any mistake made by the Crown in operating a game-by-game basis. In other words, we were not overpaying tax, and that is fundamental to the current position. We were just within the spectrum of that which is reasonable, and it would not have been open to my clients to come back out of time, as it were, many years later, because we face a 4-year time limit, obviously, for claiming, to reopen that. So because of the fact that there is a penumbra of potentially right answers, and the system, VAT system in particular, constantly works with this kind of situation, more on the input tax attribution side, where there are often many right answers. This is quite rare. This is an output tax question, which there is also potentially more than one right answer, but it's for fundamentally the same reason. How widely do you cast your factual net? You look at a game, you look at a session, you look at 5 weeks, which is the approach in bingo duty. So that is how there can be more than one right answer.
I'm still puzzled as to what there is for Section 80 to bite on, because that provides that the Revenue and Customs are liable to credit a person who's brought into account as output tax an amount that was not output tax due. But on your approach of more than one right answer, it was output tax due.
It was, my Lord. There is nothing for Section 80 to bite on, and we were within the lawful spectrum when we obeyed the pre-2007 business briefs, and we did as we were told, and we were lawfully told to do that. What has happened is that the Crown has agreed to the reopening, and it is in fact a reopening which doesn't involve Section 80. It involves proper construction of obviously the documents that came from the Crown, but as I hope to demonstrate in a moment, though perhaps after a short break, that those documents are as much of an invitation to revisit on Section 80 grounds, which are not there in my submission, and on Regulation 38 grounds.
Thank you, Mr. Kodara. Now, would that be a convenient moment for us to have a short adjournment?
My Lord, indeed, yes.
Can I suggest that instead of leaving the meeting, we simply mute our microphones and close our video feed, and then we can resume in 5 minutes' time. I think we're ready to resume, Mr. Kodara.
I'm grateful. Is it convenient now to turn to
You're muted.
Am I audible now, my lord?
Yes, you are. Thank you.
I'm grateful. Apologies. My lord, is it convenient now to turn to the notice 700/45?
Yes.
Which is dated in the version that I have. I have it at at page 1745. But that may not be the same page number that your lordships have.
No.
The version I have is dated March 2002.
Yes, that's what we have also.
And I believe it to be the relevant version, even in 2007. Again, the version I have has got some updating towards the back. So I will address your lordships on that assumption. I hope it doesn't prove to be ill-founded. And the point of my showing this document to your lordships is that, well, first of all, it's headed "How to Correct VAT Errors and Make Adjustments or Claims," and within it, if one goes to I think one goes to page 17. I'm so sorry. The document page 5 of 42, 1749 in the bundle that I'm using. That may not help. There are two different methods for correcting errors. This is pure background. So we don't say, and I believe the commissioners don't say, that we made an error in following the original notices. So this is pure background. One then turns a couple of pages to document page 7 of 42. There is 4.7. Should I correct errors that don't affect net VAT that I declared? That's background. Then 4.8, which is foreground. What about adjustments that aren't errors? And there is a list of a bullet list. And the last one on the page is issuing or receiving credit and debit notes. And that is the closest we get to the current situation, i.e. where a supply has been made, but the consideration is altered. Supply has been made, but the consideration is altered. And then if one turns to section 9, which comes at page 16 of 42, or the page numbering I'm using, page 1760, there is a heading, "How to deal with other types of adjustments. What about adjustments or claims that aren't errors?" And your lordships will notice the phrase "adjustments or claims that aren't errors." And I pointed out when I was showing your lordships the document at 451, which was the customs brief 07 of 07, which accompanied the move from game to session-based. There was a reference to both making claims and making adjustments. And this is the same theme, adjustments or claims. And some adjustments or claims are necessary even where you've not made errors on your returns. And then there's a reference to time limits applying. And at the bottom of the page, there's a reference to credit notes. And the detail does not concern your lordships in my submission. We did issue a credit note. It was inevitably a credit note that we couldn't send to anybody, but it's part of the story. And at 9.8, on page 17 of 42, page 1761, there is a reference, and this is a 2002 document, to a time limit of 3 years for making such an adjustment. So, and at 9.9 over the page, there is a reference to how one makes that adjustment, subject to the 3-year limit. That we submit that is a reference not to section 80, which we say does not apply in this case, but to regulation 38, which we say does apply, which is the regulation that enables changes of consideration. Here it's obviously deemed consideration to be made. My lords, I've shown you that 9.8 and 9.9 because by reason of a later decision, and this is a footnote only, but it's important to bear in mind, by reason of a later decision, Sir Stephen Oliver, the president of the tribunals, held that in the context of Regulation 38, which we'll look at in a moment, a 3-year time limit was not appropriate. The detail doesn't matter. It's available, and I can go to it. It's at tab 61. It's the GUS case. And within tab 61 at paras 64 to 65, Sir Stephen Oliver explains why the time limit, 3 years for making adjustments, is unlawful. And in 2009, the law was amended, as we'll see. That amendment wasn't in place in 2007. A curious footnote, but it means that given that the law, as we'll see, wasn't amended until 2009, 2007, when the notices which your lordships are looking at were issued, the assumption would have been that there was a 3 or 4 year time limit on Section 80 claims and a 3-year time limit on Regulation 38 claims. Moving forward to today, our position is that, and this may be common ground, we'll see, that Section 80 doesn't come up in this case because there was no error made. We followed a reasonable approach by using the game basis. And as we'll see, Regulation 38 doesn't have a time limit. It's not appropriate for it to do so. And therefore, we can have the current debate on the basis which going forward. But in 2007, that wasn't known. So, my lords, if I may move to the statutory material, which obviously embodies the provisions with which your lordships are concerned. I can do this relatively rapidly because there is perhaps not very much to say about them. I think I've taken your lordships already to to page 488 of the bundle, which is Article 73, and we looked, I think, at Article 90. An observation that I make straight away is the word consideration is used in Article 73. The word price is used in Article 90. But I will explain the basis of what I'm about to say in a moment, but I think it's now common ground that price and consideration should be taken to be synonyms. And there is that nothing turns on that distinction, and that was the basis for a message, very helpful message from the Crown on Monday, whereby it doesn't seek to support references in the decision of the Inner House which give price a much narrower meaning, price in Article 90, in consideration. I think it is now common ground that both Articles 73 and 90 are dealing with what in VAT terms is consideration. Your Lordships will know this, but Article 73 is the successor to Article 11A1A, and Article 90 is a successor to Article 11 capital C. See pages 471 and 472 of the bundle. I don't invite your Lordships to turn to that. The UK implementation, so far as it is relevant, of course, is to be found, first of all, in section 19 of the VAT Act, subsection 4. That's page 513 of the bundle. 513, that's section 19, the value of supply of goods and services. Your Lordships are, in my submission, concerned with 19.4, which says, where the supply of any goods or services is not the only matter to which a consideration in money relates, the supply shall be deemed to be for such part of the consideration as is properly attributable to it. So the customer hands over her or his money at the bingo hall, and we know from the case law that some part of that money is consideration for the experience, and other parts go into the pot as prize money. And the process, obviously, with which this case is concerned, therefore stands within section 19.4. Your Lordships will obviously see that the word deemed appears, and as with any apportionment case, there is very frequently a spectrum of acceptable answers bounded by, at each side, unacceptable answers. And I've made my point already that both game-based and session-based are within the spectrum of acceptable answers. Hopefully that's common ground, but we shall see. My Lords, that just leaves two other things to notice. One is Regulation 38. Regulation 38 is the implementation of part of or regulation of Article 90 of the directive. There are two versions to note. There is one version which is the up-to-date version, which is at page number 635. And the up-to-date version, in material part, is the same as it was at the time. And at 635, Regulation 38, this regulation applies where A, there is an increase in consideration for a supply, or B, there is a decrease in consideration for supply. We say in the latter, so 38(1)(b) situation. And as your Lordships will see on that page, there are then some square brackets, which I will return to, because those square brackets were only emptied in 2009 and were full in 2007, when the documentation to which I've referred already, the public notices were issued. The other material parts of this document as it currently stands, if your Lordships could turn to the next page, 636, it refers at sub 7. It says at sub 7, none of the circumstances to which this regulation applies is to be regarded as giving rise to any application of regulations 34 and 35. And then there's a square bracket which was added in 2019, which perhaps one can ignore. What that does is draw a very clear line between situations where there has been a Section 80 type mistake. Someone has paid a sum of money which isn't due. That's the error correction machinery to which I will refer in a moment. And there is therefore a clear line between Regulation 38, situation where there is a change in consideration between simply paying more tax than was due at the date of the payment. My lords, that just leaves two references. I hesitate slightly because it takes us, but it may well be, there won't be a problem. It takes us to a page that I have referred to in my notes as page 1802. That may not be problematic if your lordships have received a recent bundle, perhaps today or yesterday, which...
We received a bundle with authorities 83 and 84 on it.
I think that might well be, yes, my lord, that is it. I'm most grateful. What one has here is at page 1802.
I'm afraid our numbering is different. This bundle begins again at page 1.
Yes. A mental calculation suggests we'd be in the region of page 9. I'd be embarrassed if we're not. In other words, Regulation 38.
We can go on a bit further.
It is 1802 at the bottom right.
That is the one I have in mind.
Yes, so it does.
I showed your lordships a second ago, page 635, which was the current version of that Regulation 38. This is the version that was extant in 2007 when the various notices that we looked at moving from from one basis, from a game basis to a session basis, were issued. This is what would have been in the mind of the issuers of the notices and indeed taxpayers at the time. And no material change in the one that matters, 38.1b, that's in a sense what the appeal is about. 38.1 capital A is what was deleted in 2009 as a result of the case to which I made reference, which was decided in 2003. And 38.1a limits the change to 3 years. And what was held in the case, was that that's not appropriate because this is dealing with events in the context not of the past being wrong, but just the future, as it were, being changed. Therefore, that provision, 38.1a, would have been in everyone's mind, no doubt when reading the 2007 documentation, but it was later demonstrated not to be correct, and just be helpful to look for a moment, if I can find it quickly. Would your lordship just bear with me for one moment? I apologise for hiatus. I will have to, I don't want to keep your lordships waiting. I'll just have to find it in a moment. I apologise. I apologize. I've mislaid. I temporarily mislaid the reference. So, my lords, I will come back to that case. That then brings us to the message received by the registry yesterday. I don't have a bundle page for it. I just have an email dated the 27th of April, 2020. This is from the Advocate General's office, indicating that the word consideration in Regulation 38, which we've just been looking at, should be construed in line with the approach adopted in by the directive, principle of that directive, in Article 73, and therefore Articles 73 and 90 are aligned, notwithstanding that the wording is different. That means, if one can turn momentarily to the decision of the Inner House, to paragraph 71, which can be found, I think, at page 241 of the bundle. The Crown don't support Lord Drummond Young's conclusion there. He says there, his lordship has been speaking of section 19.4 of the VAT Act and so forth. He says of that argument, 71, this argument is dependent on the proposition that consideration as used in Regulation 38 has the specialized meaning that is used in normal VAT contexts, namely the part of the sum received by a supplier that the supplier is entitled to keep for his own benefit. And his lordship goes on to give it a narrower meaning, and it is common ground, and hopefully that will commend itself to your lordships, that the meaning of that word is its, quote, normal VAT meaning. And that means that the search in terms of what is to be treated as the consideration, both in Article 73 and Article 90, is for the self-same concept. Perhaps in due course, when the commissioners their term comes, I'm looking now at paragraph 57 of the decision of the Inner House. This is at page 232, paragraph 57 at page 232. There is a reference there, there's a title, Further Considerations Relating to Article 90 in Regulation 38. I'm raising a small point. We presume that the Commissioner's indication, to which I've just made reference, is not limited to Regulation 38, but includes the wording of Article 90 itself. In other words, the Commissioners accept that both Articles 73 and 90 of the directive are pointing to the same underlying concept, namely consideration in the true that sense. So, my lords, that if that be right, then consideration in Article 73 concept is aligned with Article 90, and that means that one objection to the approach taken by the Commissioners stands out because commissioners historically appear to have treated the concept of consideration as possibly being approached in a different way as between Article 73 and 90. Whether that's right or wrong, we certainly invite your lordships to approach them as being labels for the same thing. And in this case, as I've already made plain, we accept that the concept of game by game approach was within the spectrum of valid concepts and therefore engaged Article 73, and it is our case that the session-based approach is also valid, and that will engage Article 90. So, my lords, I leave that and come, mindful of the time, to the next phase, which is just to dip into, but perhaps not very extensively, the cases which give some guidance as to what consideration is. I won't trouble your lordships unless requested to look at the Lex case. We've set out the background to the normal approach to valuation in our case at paragraphs 16 to 23. That's in the normal case, not this case. Those paragraphs are to be found at pages 111 to 114 of the documentation. And we quote from the decision in Lex, which is at tab 14 of the authorities bundle, where at pages 1087 and 1092, if perhaps one can look very just briefly without needing to read it, but Lord Walker, in the Lex case, the facts of which are not relevant, very different. It's a case of apportionment, but in a very different context. But at 1087, or 1086, forgive me, the case starts, and at 1092, at paragraph 118, his lordship, particularly at letter D, speaks about the subjective value and the basic approach to identification of that consideration. That, of course, as his lordship makes plain between letters C and D, involves a value overtly agreed. Again, at the start of para 19, his lordship says, if I may quote, subjective value is therefore in a straightforward case the value which the parties to the contract have themselves recognized in the course of their dealings and have in that way attributed to goods and services which amount to non-monetary consideration. The problem, of course, of the current cases like it, there is no overt agreement, and that is why there can be more than one right answer always within the spectrum of legality. And therefore, one unfortunately has to leave, for the purposes of resolving this case, one has to leave that world of certainty and enter into the more difficult waters of the case law of both, above all, perhaps the Elida Gibbs case, and there is also another very recent case to which I will refer in a moment. But can I hopefully deal with both of those cases, which are quite important, in the next few minutes? Can I invite your lordships to turn to the Elida Gibbs case, which is at Authorities tab 31, it is in many ways my best case. The Finance Ant Bingham case is also helpful, but in my submission, this is the case where your lordships will find the most guidance, and it's page 742 of the bundle. It deals with a radically different set of facts. We're not remotely in the area of gaming or gambling. In this case, if I can summarize it, one had a supply chain, Elida Gibbs making toothpaste and so forth. They would either retail directly or, more helpfully from the point of view of the current analysis, would sell to wholesalers who would then sell to retailers, who would then sell to the public. And the Elida Gibbs had various promotions, and people could react to those by sending in coupons and getting money. Buys one's toothpaste, sends the coupon in, one gets the money directly from Elida. Or alternatively, the supermarket, with whom Elida may not have any direct contractual relationship, honors the coupon, the person gets the discount from the supermarket, and then the supermarket acquires the rebate from Elida. So it's a leapfrog situation. The question for the court, the European Court, was what is Elida's VAT turnover? The Advocate General, in agreement with the United Kingdom and Germany, took the view that the events, these remote events, remote from Elida, whereby people would buy toothpaste, say, get the coupon which they could use, did not affect Elida's turnover. And the court differed and took a much more holistic view. And it's a view which is very much the centerpiece of our case. If I can direct your lordship's attention to the judgment, and the judgment, as I say, differed from the opinion of the Advocate General. At page 755 of the documentation, one sees at paragraphs 5 and 6 two types of money off coupons. The details don't matter, save to say that what this case does involve is, as it were, a leapfrog of relationships along the line from supplier, wholesaler, retailer to customer. The customer would brandish a money off coupon at the counter, say, in the chemist, would buy the toothpaste, and then in the case of the money off coupons mentioned in paragraph 5, that would be a coupon obtained, say, from the newspaper. The customer would use that to pay in part for goods. And in the case of the paragraph 6 money off coupons, the retailer themselves would create the coupons. What's critical is at 7, whether the buyer of the company's products is a wholesaler or retailer, the company charges the supplier a specific VAT-inclusive price, which it invoices to its buyer under both variants of the money off coupon schemes described above. The amount invoiced for the supply is determined in respect of any present or future promotion scheme. Thus, the wholesaler or retailer may not know when purchasing goods from the company those goods are or are to be the subject of a money off coupon promotion scheme. At that stage, it may be that no scheme is in existence or even planned. So pausing there, well, I should read on. Sales by wholesalers to retailers take place at the wholesalers' prices, which are likewise unaffected. So the striking part heart of this case is that there was, and indeed this was the decision, there was nothing wrong or indeed even later changed in terms of the VAT levied by Elida Gibbs on its immediate counterparty, say the wholesaler in the supply chain. Events which later reduced it may at that stage not even have been put in train. However, as we'll see, when at a later stage those events occurred, they had the effect of enabling Elida Gibbs subsequently to reduce its taxable turnover. So it is a very striking case, and if your lordship would be kind enough to turn to page 756 of the bundle, 1401 of the judgment, they will see the mechanics of this in paragraph 9, which is simply what happens on the supermarket shelves, and then an important paragraph at 10, which reads, if I may briefly read it, moreover, under the basic scheme, the retailer makes its redemption applications directly to the company. Only the retailer and the company are concerned with the transaction, with this transaction. The retailer is entitled to redemption provided that he shows that he's made sufficient purchases, that the product in question was bought by him from the company or from a wholesaler, and that it was purchased before or during the period of the promotion campaign. In the case of the retailer-specific scheme, the coupon must be redeemed by the company, irrespective of whether the product in question was sold by the company before or during the period of the promotion scheme. So one has essentially a leapfrog discount offered by the manufacturer to parties who may well be strangers to it, in the sense that it isn't the retailer and there may be an interposed wholesaler. But the question before the court was, can that impact on the turnover of transactions which, as we've seen at the bottom of the previous page, may well be passed, and VAT might well be correctly, as the facts then stood, might well have been correctly accounted for. And the questions appear at bundle page 757, report page 1402. I won't read them, but they refer to the predecessors of Articles 73 and 90 of the Principal VAT Directive. But the thrust of each question is, do these later events reduce the taxable amount, and how? And now I finally, with apologies for that slightly long run up to the wicket, I come to paragraph 90, which is on bundle page 757, report page 1402, paragraph 19, I should say. That reminds us that the basic principle of that system is that it is intended to tax only the final consumer. Consequently, the taxable amount serving as a basis for the VAT to be collected by the tax authorities can't exceed the consideration actually paid by the final consumer, which is the basis for calculating the VAT ultimately borne by him. And that underpins the appeal, the consideration actually paid by the final consumer. Of course, in this case, the case before your lordships, that has to be worked out using the principles in the cases, in the gaming cases, which I'll come very shortly. And there can be more than one right answer. That's a point I made earlier, depending on where within the permissible spectrum the relevant period is drawn. Turning the page to bundle page 758, report page 1403, there is a heading halfway down page 1403, paragraph 26, which summarizes and this is the core reasoning. First of all, at 26, it summarizes the background. 11A1A is now, of course, Article 73 of the PVD. 27 refers to the subjective value, that is to say, the value actually agreed. We don't have that in these cases. We've simply got the overall amount that the punter pays the bingo hall. And there is no further engagement, mental engagement between the receiver of the supply and the supplier as to the consideration than that. That is why this is the Glaber-Spiel area is a very particular area, because those operating the tax have to identify some form of guide to what is deemed to be the consideration. Then at 28, which I won't read aloud, they deal with receipt on what the manufacturer gets on completion of the transaction, and halfway through there is one sentence which I will quote if I may. It would not therefore be in conformity with the directive for the taxable amount used to calculate the VAT chargeable to the manufacturer as a taxable person to exceed the sum finally received by him. Were that the case, the principle of neutrality of VAT vis-a-vis taxable persons, of whom the manufacturer is one, would not be complied with. Then there's a reference. Up to that point, the court has been discussing Article 11A1A, which is, of course, now Article 73. It then, at paragraph 30, moves to make a parallel analysis of Article 11C1, which is now Article 90. It treats that as an auxiliary to, I'm looking at para 30, to its earlier analysis. And then it says this at 31, which is important for my case. It broadens what might otherwise be the literal meaning of Article 90. It is true that that provision refers to the normal case of contractual relations entered into directly between two contracting parties, which are modified subsequently. The fact remains, however, that the provision is an expression of the principle emphasized above. The position of taxable persons must be neutral. It follows, therefore, from that provision that in order to ensure observance of the principle of neutrality, account should be taken when calculating the taxable amount of VAT of situations where a taxable person who, having no contractual relationship with the final consumer, but being the first link in a chain of transactions which ends with the final consumer, grants the consumer a reduction through retailers or by direct repayment of the value of the coupons. Otherwise, the tax authorities would receive by way of VAT a sum greater than that actually paid by the final consumer at the expense of the taxable person. Pausing there, that is, as it were, the leapfrog dimension which the Elijah-Gibbs approach brought to that story. There is no leapfrog in our case, but we are dealing obviously with, unlike Elijah-Gibbs, where there were very clear contractual figures, there was a discount voucher with a discount on it, and there was therefore no contractual doubt as to what was the original consideration, what was the subsequent discount. In our case, we don't have any of that material. All that the punter knows is what they pay at the door, and they never discover any subset. So that has to be constructed by the taxing authorities, ultimately perhaps the courts. And at that point, therefore, there isn't a direct parallel, but what one does have is an indication that one has to look not just at the first link in the chain, but the overall bottom line, if I may refer to it in that way. And we say that the parallel in the current case, before your lordships, is there was one approach. The taxing authorities said you may retrospectively apply a different approach. And that, we say, analytically is equivalent to the voucher coming in from Boots or someone to Elida later, it's a differently structured story. But what one has is a later event that permits a revisitation of what was an earlier settled position. And of course, the earlier settled position, at least in Elida Gibbs, was settled overtly between, in the real world, between the various commercial parties in the chain. We don't have a chain, we've just got two parties. But by contrast, of course, there is no overt settling of any position at either stage 1 or stage 2. The whole process which your lordships are considering is one which involves the taxing authorities directing or inviting an approach, and then, as we've seen in 2007, permitting a revisitation of that approach. That's why we say it is appropriate to read across from the Elida Gibbs case to our current case. That's the main point that comes out of Elida Gibbs. There is a subsidiary point. So I made my, if I may put it this way, I've made my big point. The text of the judgment goes on to deal with, at 32 and 33, to repel, or rebut, I'd rather, an objection made by the United Kingdom, the Greek and the German governments to that approach. And they had successfully persuaded the Advocate General to take a different approach, which the court did not follow. And what happens at 32 and 33, and it's very striking, and it's this. The objection being, well, if the approach that the court ultimately took is right, then everyone, it's very laborious, everyone going down the chain, from the toothpaste manufacturer to the individual in boots, has got to solemnly readjust their tax returns. And the court in 32 and 33, which I won't read, save for perhaps the first line of 33, brushes that aside. And it says, very strikingly, first sentence of 33, quote, "The VAT system is not disturbed as a result of such deduction, since there is no need to readjust the taxable amount for the intermediate transactions. On the contrary, that amount remains unchanged, since for those transactions, observance of the principle of neutrality is ensured by the application of the conditions for the deduction set out in Title 11 of the 6th Directive." So the lengths to which the court went to ensure that VAT was not collected on a greater sum than was ultimately suffered by the consumer is underlined by this very striking and I think unique, as far as I'm aware, unique approach. So it's essentially, we don't have to grapple with this in our case because it's simply a bilateral relationship. But I mention it to your lordships perhaps as a measure of how strenuously the European Court expects member states to ensure that VAT is not paid or retained for something greater than what is agreed to be the true consideration. I won't read, but it is of importance to note paras 34 and 35. Well, I won't read 34, which essentially puts together Article 11A1A, now 73, and Article 11C1, now 90, into a single machinery. And I don't believe that is controversial. I say that because the Commissioner's indication that they don't seek to support the inner house on the question of possibly a narrower meaning of Article 90 and its reference there to the money moving. But if there were any doubt, then it's clear from 34 that articles, in our updated case, Articles 73 and 90, operate as a single seamless machinery. And we say this is a very simple case at bottom. The Crown has very properly said things have been going forward on a basis which is not the only basis. There is another basis which we, the Crown, will accept. That is to say, the session basis. You may retrospectively revisit that. You may only do so for 3 or 4 years, because at that time that was how things were perceived. I'll come back to what I mean by that in a moment. But as soon as any number of years are open, even if it were 1 year, we say that it must follow that process should relate back whenever the original but now replaced accounting methodology started, and that takes one back to the beginning of the story. My client's current position, as you'll also be aware, is that they've had 4 years, but no more than 4 years. That retrospectivity, if I may just digress slightly, was based on the supposition that this was a Section 80 mistake claim. I'm not sure I can say it's quite common ground, but we appear to be moving towards common ground. That is not the case. That we operated or we took up a lawful offer, as it were. Whether it was binding and obligatory or not is a separate question, but it was a lawful offer based on a sustainable reading of the case law. And the Crown commissioners have offered a reopening, in which case we're not in a Section 80 case at all, and we are in a Regulation 38 case. The commissioners, as they are entitled to, say, well, you must make your Regulation 38 case good, which I am endeavouring, of course, to do. But ultimately, everything turns on Articles 73 and 90 of the directive. And it is common ground that, counting backwards, as it were, from year -1 to -4, before the 2007 revised approach, we are entitled to revisit and rebase the calculation on the basis of the session. And all this appeal is about is whether we can continue that process on the basis which is accepted as lawful, albeit originally, I think, as a Section 80 claim. Now, it really can only be lawful on the basis of a Regulation 38 claim. The issue is whether we can go back for those extra years as well. If I digress slightly, and I apologize, I should complete the presentation of this case. I'm mindful of the hour. Going back to the case, again, with renewed apologies for the digression, at paragraph 35, the court appears at that point to treat Article 11A1A and Article 11C as really a unified machinery which achieves one overall objective, which is to ensure that VAT is recovered on the correct amount. I won't read 35, but it puts those two together as effectively working towards a single outcome. My lords, I was going to turn, and what I have been saying, I should say, is reflected in our case at paragraphs 35 to 39, which can be found on pages 119 to 120 of the bundle. The next matter to which I would come is a more recent case in the same vein, the Finanzamt Bingen-Alzey case. That's in the new bundle at page 181. 10. I'm mindful of the time, and I'm in your lordship's hands as to whether to continue or to take that up after the short adjournment. I don't detect any great enthusiasm for dealing with it now, I think. I'd say so.
We seem to have lost Lord Reed temporarily, so shall I take the initiative and say we'll adjourn now and resume again at 2 o'clock?